Friends, contingent means something which is dependent upon some uncertain event or something which is left to chance. Contingent contracts are covered by Section 31 of the Act. These are the contracts where the performance of the contract is dependent upon happening or non-happening of some uncertain events in future. For example, A contracts with B to sell 1000 liters of oil at 100 rupees per liter if he is able to successfully import the oil from China. Here the sale of oil is dependent upon import from China. If A could not import the oil from China, then he need not perform the contract. Take another example. A agrees to give loan to B if A is elected as the president of Bar Council of Delhi. This is again a contingent contract as the performance is dependent upon A becoming a president, which may or may not happen. Clear? Now friends, can you think of some most popular types of contingent contract? I'm sure you must have also entered into some type of contingent contract some point in your life. Just think it over. Okay, let me remind you. Remember that car insurance you have taken? Remember that life insurance you have taken from LIC? Remember that health insurance you have taken? Yes, friends. Insurance contracts are one of the most popular contingent contracts we all make. So, what happens in an insurance contract? The insurance company agrees to compensate you for any loss you suffer due to an uncertain event, say theft of your car, or if you get admitted to hospital, or in case of your death. So basically, insurance company agrees to compensate you for an event which may or may not happen. Your car may get stolen during the policy term, or it may not get stolen. You may get hospitalized or you may not get hospitalized, right? So insurance contracts are a type of contingent contract. Another type of contingent contract is a contract of indemnity and guarantee. In contract of indemnity, you agree to save the other party from the loss suffered because of your representation or your actions. In a contract of guarantee also, you agree to compensate the third party in case of default by the second party. So these are some of the common contingent contracts. Now let's get on to the definition of contingent contract as given by Section 31 of the Act. According to Section 31, a contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. Friends, the word collateral is very important here. I'll tell you why. Collateral event means some secondary event, something which is not related to the main activity being performed under the contract. Let's understand it through an example. Mr. X contracts with Mr. Y to paint Mr. Y's house. Mr. Y says that no payment shall be made until the completion of the work. Is this a contingent contract? Because there is a condition in the contract that the payment will be made only upon completion of the work. So can we say this is a contingent contract? Well friends, this is not a contingent contract because payment upon completion of work is not a collateral event. In fact, it is a reciprocal promise or very much part of the contract itself. Take another example. A contract for sale of goods where the seller agrees to deliver the goods within a week if the buyer makes a payment within 2 days. Is this a contingent contract? No, this is not, because payment within 2 days is very much part of the contract. Collateral even means some activity which is not to be performed under the contract, but it is related to the contract on which the contract is dependent. Take one more example. Mr. A agrees to pay Mr. B 5 lakh rupees for constructing a building provided construction plan of the building is approved by an architect. Now this is a contingent contract because the contract was made to construct the building and not to get the building plan approved. Approval of building plan is a collateral event which may or may not happen. So for a contingent contract, the contract must be dependent upon the happening or non-happening of an event collateral to the contract. I hope the distinction is clear. So a contingent contract is formed in the following two conditions. The performance of such a contract is dependent upon happening or non-happening of some uncertain future event. Second, such uncertain event must be collateral and incidental to the contract. Okay, now in next lecture we will discuss certain rules regarding contingent contracts. Now, having understood the meaning of contingent contract, let's discuss certain rules with respect to contingent contracts. These rules are covered under section 32 to 36. Section 32 says a contract, performance of which is dependent upon happening of future uncertain event, cannot be enforced until such uncertain event happens. And if such event becomes impossible, such contract will also become void. For example, Mr. A agrees to sell his watch to Mr. B for a fixed price if Mr. C refuses to buy his watch. This contract cannot be enforced until and unless Mr. C refuses to buy the watch. Another example, A agrees to give a loan to B when B marries C. C dies in an accident. The contract becomes void as B cannot marry C now. Under section 32, we discussed contracts which are dependent upon happening of uncertain event. Under section 33, we will discuss contracts which are dependent upon non-happening of uncertain event. Section 33 says, a contract to do or not to do anything, if an uncertain future event does not happen, can be enforced when the happening of that event becomes impossible and not before. This is because until the event becomes impossible to perform, there will always be a chance that such event may happen, in which case contract cannot be performed. So such contract can be enforced when it is certain that event will not happen anymore because it is impossible now. For example, an insurance company agrees to pay a fixed sum of money if a certain ship does not return. The ship gets sunk in the sea while returning. The contract can be enforced when the ship sinks because return of ship has now become impossible. Clear? Now, section 34 says, if a contract is contingent upon how a person will act at an unspecified time, the event shall be considered to become impossible when such a person does anything which renders it impossible that he should so act within any definite time or otherwise than under further contingencies. For example, A agrees to give a loan to B if B married C. C married D. Marriage of B and C becomes impossible, though it is possible that D may later die and then C marries to B. But once C married D, the marriage of B and C is considered impossible, and even if B marries C later after the death of D, A is not bound to give a loan to B because the obligation under the contract has ended as soon as C married D, and this contract cannot be revived again. Now, coming on to section 35. Section 35 has two subsections. Section 35 subsection 1 deals with contracts to do or not to do something if an uncertain event happens within a fixed time. According to this section, if an uncertain event does not happen within the fixed time for it, then the contract becomes void. Even if the uncertain event becomes impossible before the expiry of the time fixed, the contract will be void. Take an example. A contracts to give a loan to B if a certain ship returns within a year. Now, this contract may be enforced if the ship actually returns within a year. On the other hand, if the ship does not return within a year, the contract will become void. Also, if before the completion of 1 year, the ship sinks in the sea before reaching its destination, then also contract will become void because it is impossible now that the ship will return within a year. Clear? Now, section 35 subsection 2 also talks about a similar situation. Section 35 subsection 1 covered happening of certain event within a fixed time. Section 35 subsection 2 covers if a specified uncertain event does not happen within a fixed time. According to section 35 subsection 2, a contract to do or not to do anything, if a specified uncertain event does not happen within a fixed time, may be enforced if such uncertain event does not happen within the time fixed for it. Such contracts may also be enforced before the expiry of the time fixed if it is certain that such event is not going to happen. Let's take an example. A contracts to give a loan to B if a certain ship does not return within a year. Here the contract will be enforceable if the ship actually does not return within a year, or if the ship sinks within a year, thereby making it impossible to return. Clear? The last type of contingent contract is covered by section 36. Section 36 says an agreement to do or not to do anything if an impossible event happens is void irrespective of whether the impossibility of event is known to the parties or not at the time of entering into the agreement. The logic is simple here. If you make a contract dependent upon some impossible event, then the contract is never going to be executed. For example, A agrees to give a loan of 10,000 rupees to B if B's dead father becomes alive again. This agreement is void because a dead man cannot become alive. Another example, A agrees to give a loan of 10,000 rupees to B if B marries C. Neither A nor B knew that C was dead at the time of entering into the agreement. This agreement will also be void. So these were the rules related to contingent contracts covered by section 32 to 36. Hope this is all clear to you. Now, one of the important topics that is often asked in the examination is the difference between wagering and contingent contracts. We are making a distinction here because contingent contracts and wagering agreements appear to be same, but they are not same. Let's discuss some of the differences. First point of difference is that contingent contracts are valid contracts, while wagering agreements are void. Second point of difference is that under contingent contract, parties have a real interest in happening or non-happening of an event on which the contract is dependent upon. But in wagering agreements, parties are interested only in winning or losing the bet amount and not interested in the occurrence of the event. Third and last point of difference is under contingent contract, the future uncertain event is collateral to the contract, while in wagering agreement, future uncertain event is the sole determining factor of the agreement.